Can a landlord pick and choose their tenants based on race or other factors? Hi, I'm Simon Dupinard and I'm an attorney. The answer is no. Property owners are perfectly entitled to vet prospective tenants. It is legal and advisable to carry out a credit check and ask for references. A landlord has a right to know that a tenant will be able to pay the rent on time and will look after the property respectfully. However, it is illegal to reject a tenant application on the basis of sex or race, or any other quality, such as sexual persuasion, religion, age, etc. Not only are these basic rights enshrined in the Constitution, they are also protected by the Rental Housing Act, which allows for the prosecution and imprisonment of landlords and estate agents who unfairly discriminate against prospective tenants. Now, recently, an individual was refused the right to apply to rent a property in Cape Town CBD by an estate agent. The agent told the prospective tenant that, quote, the client is race specific, unquote. This not only contravened the RHA, but also the Promotion of Equality and Prevention of Unfair Discrimination Act, known as PEPUDA, I'll call it. This act was a criminal offence. Section 4 of the RHA states, in advertising a dwelling for purposes of leasing it, when negotiating a lease with a prospective tenant, or during the term of a lease, a landowner may not unfairly discriminate against such prospective tenant or tenants, or the members of such tenant's household, or the visitors of such tenant, on one or more grounds, including race, gender, sex, pregnancy, marital status, sexual orientation, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, language, and birth. This section refers to landowners, but landowner includes the owner's duty, authorized agent, or a person who is in lawful possession of the dwelling and has the right to lease or sublease it. Section 16 of the RHA continues. Any person who fails to comply with Section 4 will be guilty of an offence and liable on conviction to a fine or imprisonment not exceeding 2 years, or to both such fine and both imprisonment. Both PEPUDA and the Rental Housing Act prohibit unfair discrimination, but what constitutes unfair discrimination? In certain circumstances, different treatment does not perpetuate patterns of disadvantage and harm. Thus, the different treatment will be permissible, although these circumstances are rare. Example might be a women-only residence set up as a place of safety for women who have suffered abuse. In this case, it is not unfair to refuse to rent to a man. Unfortunately, discrimination doesn't begin and end with the two parties of the lease agreement. It is not unheard of for body corporates or other tenants of a building to harass tenants of color or their guests in a manner that equates to unfair discrimination. It has been known for a body corporate to hint to security that cars or drivers fitting a certain description should be treated with suspicion. The guard who waves one car through with barely a glance but subjects the next driver to exaggerated scrutiny is an example of discrimination thinly disguised as security. However, the protective measures apply to everyone, and discrimination of this nature is in contravention of PEPUDA. Tenants who experience any form of unfair discrimination can take those responsible for it to the Equality Court. If you think you are the victim of unfair discrimination, or if you need advice on any aspect of landlord-tenant relations, contact me, Simon, on 086 099 5146. I stand against discrimination of any type and will fight for your rights.